Hi guys, Tom Green checking in.
Hello. All right, so looks like we have everyone except Toby.
Shall we give it another minute or two, or?
Yeah, let's give it another minute and then we can begin the meeting.
Okay. And who's taking roll for us this morning or this evening?
I will be. Me?
That's
Mimi.
Yeah. Oh, Mimi. Perfect. Thank you.
Okay. So before we begin, if there's any members of the public who intend to give public comment, can you please use the raise hand function and indicate that you'd like to do so?
So Mimi, do we have any folks from the public that want to speak, or?
We do have one. So
Okay.
We'll get to that when we get to that portion of the agenda. Maybe we can begin and maybe Toby will join us in a bit. It looks like we now have a quorum and we will begin the meeting. This meeting is being recorded, and with permission of the chair, I will start with the roll call.
Yeah, please do, Mimi. Thank you.
Okay. Tom Green.
Here.
Rebecca Sandifer.
Present.
Marta Alkenbrock. Marta, I think you're muted.
Pardon me. Here.
David Engstrom.
Here.
Micah Star Liberty.
Here.
Kevin Moore.
Here.
Toby Rothschild.
Here.
Patricia Scutiero.
Here.
Thank you. The next item on the agenda is public comment, and it appears that we have, hold on, I lost my Zoom window. Okay. We have one member of the public who'd like to give comment. You'll be given 2 minutes to speak, beginning now.
Great.
Leonard. Leonard, are you there?
I see the little audio boxes jumping, but I don't hear anything.
It looks like he's trying to connect to the audio, so maybe in
Okay.
just a minute we'll
Give
be
it a
able to
second.
hear him. Are you there, Leonard? No, he's not. I thought he was.
Okay.
Shall we come back to Leonard when his audio works, or what do you think, Mimi?
I leave that up to Andrew.
Yeah, I think one option, Tom, is to just do approval of the action summary, some of the brief house cleaning items, and then we could try Leonard one more time before we get to the substance of the meeting.
Okay, that sounds fair.
Yes, Leonard, if you're able to get your audio working, perhaps you could use the raise hand function again to let us know that you're ready. Okay, so we'll move on to, I guess, announcements.
Okay, I don't have any, but Andrew or Lauren, do we have any announcements?
I do not have any prepared announcements.
Okay. Then the next item on the agenda is the approval of the open session action summary from the March 26, 2021 meeting.
Move to approve?
Okay,
Do I hear a
Cody?
second? Do we have a second?
Sure.
I can second.
Okay, Marta is seconded. Any objections? Going once, going twice? Any
Well, we'll ju-
abstentions?
We have to take a roll call vote since we're
Oh, we do?
doing this. Yes, since we're doing this meeting
Okay,
on Zoom. Okay, Tom Green,
yes,
Rebecca Sandifer,
Yes.
Marta Alkenbrock,
Approve.
David Engstrom,
Yes.
Micah Star Liberty,
Yes.
Kevin Moore,
Yes.
Toby Rothschild,
Yes.
and Patricia Scutiero.
Yes.
Okay, thank you.
okay, subject to Leonard being able to communicate with us, why don't we go ahead and get started?
Oh,
Or should we go back to Leonard now?
it
maybe-
looks like Leonard is now raising his hand. So Leonard, you will
Okay.
You have permission to talk now, and you'll have 2 minutes beginning now.
Okay, can everybody hear me?
Yes.
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 Great. Thank you all for your patience and thank you for your understanding and letting me jump back in. My understanding from having reviewed the meeting minutes rather, is that the assignment for today was for this subcommittee was to prepare an application process and criteria document, and specifically the Utah model was offered as a possibility. And I should say that I am a member of the executive board of the California Employment Lawyers Association. I practice in Los Angeles and I'm based in Los Angeles, practice throughout the state, virtually exclusively in employment law, plaintiff side employment law. There's certain elements of the Utah application that are troubling to me. Specifically that suspended or disbarred lawyers could hold even a 10% ownership in any Sandbox entity. That seems to directly conflict with the mandate that the Sandbox was not meant to be a mechanism by which out-of-state lawyers could practice in Utah. Seems like that would be an end around for disbarred or suspended attorneys from practicing law again. And sharing fees with non-lawyers. I know that this committee is and others are examining Rule 5.4 of the Rules of Professional Conduct. But my concern essentially is that large corporate interests could influence legal decisions by owning paraprofessional corporations, large-scale corporations. I would encourage the committee to seek to limit the number of paraprofessionals who could join together in a paraprofessional corporation. And indeed, in the Utah model, even an individual with a felony criminal history could be considered as for part of the leadership of an entity in the regulatory sandbox.
If you could wrap it up, please.
So I'll just finish, sorry, by saying that I think that any paraprofessionals should be subject to attorney supervision. Thank you.
Great. Thank you, Leonard. Let me just, before we go into our formal discussion, let me just briefly mention to Leonard, more than anyone else, that today's agenda really focuses on what information should be secured as part of the application process, not the attributes of the persons who or corporations that may be allowed into the sandbox. So today we will not be covering the question of whether a disbarred lawyer can be part of the system or not. We'll be looking at things like what should they tell us, and it is likely, Leonard, that this will be covered at our next meeting, which, keep me honest here, Mimi, I think is on the 18th of June.
That's
correct.
subcommittee meeting? Yes.
Yeah. So we may hit those issues at a subsequent meeting, Leonard. But thank you very much, and we certainly have noted all of the information and comments that you've made. So why don't we turn to and let me just briefly talk a bit about today. So essentially what we've suggested to you all is let's start with the Utah model. People have worked their way through that in another state. We're not bound to that, but I think it gives us a starting point. And conceptually, Becky and I were thinking that this would be a useful sort of preliminary agenda in terms of how we get through this. Apropos the point I just made to Leonard, we have wonderful work product from David and Kevin in terms of confidentiality, California Consumer Privacy Act on one hand, and the duty of confidentiality on the other. That is something we will get to at a subsequent meeting, but thank you very much. The quality of both pieces of work were just outstanding. We very much appreciate it. The other final thing that I need to mention is I'm in Annapolis, Maryland for a wedding. So I'm going to exit stage right in about 40 minutes and Becky will be your chair du jour. My every hope is that we can get through what we've described as section 1, but which is in fact section 2 of the Utah application process. And we have a wonderful sort of start on this with Kevin and Marta. And then to you two, do you want to just cover all of this in one gulp, or do you want us to take it subsection by subsection? To you guys, what do you think?
If you're referring to part 1 and the subsections in part 1, or
Yes, that's what I'm thinking about. Part 1 has several subsections, so you could take it as subsection by subsection, or give us an overview of your very interesting thinking about that whole portion of the application process.
Sure. Marta, you want me to take?
Yeah, why don't you kick off and I'll interrupt as needed.
Okay.
Interruption rights granted. Go for it. Yeah, Kevin.
Okay. First thing I want to mention is yesterday Marta sent me a link, and I don't want to subvert the work that we did on this memo. But she sent me a link to the Arizona application for ABSs, which takes a slightly different approach. It's more detailed approach, detailed questions for the applicants. We thought that there wasn't enough time to circulate that. And we'll be happy to circulate it, provide you with a link. I can probably upload a link, or Marta can upload a link to the chat so people can go to that website for the alternative business structures under Arizona Rule 2-709. It's the Code of Judicial Administration in Arizona. You could do a Google search as well to find that. And then they have a page that's devoted to the various and sundry applications. And we kind of like their application.
Let me ask a question to Andrew. This seems like a new piece of information. Can we discuss this even at a high level given Bagley-Keene, or can I mean, it strikes me one way to approach this is this may be a more detailed way of thinking about this, which makes sense to me. Can we talk about this, or do we have to roll this over to a different conversation under Bagley-Keene?
Well, with the disclaimer that I'm not a Bagley-Keene expert, my understanding is it's the topic that needs to be noticed. And so if we're talking about the application process, and we want to talk about the experience in other jurisdictions, I don't see that there's any problem in discussing the fact that Arizona has an application and they might ask different questions, and we want to bat that around here at this meeting. Staff can certainly upload a link and maybe add it to the material so that the public has access to all the things we're talking about today. But in terms of what we are discussing, those are the things that need to be noticed 10 days in advance. And it's based on what I'm hearing, what we're talking about is absolutely germane to to the topic. that
Yeah,
we're
now
discussing.
it seems relevant to me too. Kevin and Marta, can you sort of break this into the chunks that we've sort of circulated in from the Utah application, or do you want to just at a high level discuss Arizona as well as Utah?
Well, we can certainly, I found the application yesterday morning, and that's when I sent it to Kevin. Unfortunately, I don't think either one of us have had Kevin did a bit of a deeper dive than I did and kind of pointed to a few things that were noteworthy that I think we can touch upon. But I actually feel like this application is worthy of a deeper dive by the group in its entirety, because we have Utah to look at, and we also have Arizona, which is a slightly different structure. Whether or not I don't think it has a sandbox per se. I think it has a limited sandbox for certain areas, for a certain area that I should be more specific. So I think the application is worthy of looking at in particular because it takes it makes the applicant to disclose its any criminal conduct. It takes a deeper dive into the business organization and management that's going to be involved, which is something that Kevin and in our memo highlighted, which should be a part of an application process for the sandbox. So, given the time crunch, Tom, of kind of getting something turned around to the committee, we didn't want to give it short shrift and put it into our memo today, but I think it is worthy of a conversation for for all the panelists to look at and discuss.
That makes sense to me. I mean, just one observation. I mean, one of the things in the Utah process is, describe your management system. How are you going to assure competency and quality, for example? That's at 2.7.2, the Utah model. At a high level, they're asking things in that ballpark, but not very specifically, it seems. So let's see what progress we can make today. Maybe we can agree on some things at a high level, but I think I agree with you too, that I think having the input of the Arizona process makes a lot of sense.
Can I ask, what's the number again, Kevin, for the Arizona Code of Judicial Administration?
It's 2-709.
2-709. Okay.
I'm trying without limited success to copy the link into the chat, and I'll continue to do so as we.
Yeah, if you could provide me with that, if you need me to, I can share the whatever is on their webpage.
If you just, I just tried it. If you just Google Arizona ABS application, it comes right up.
Yep.
Yes. Okay.
Okay.
Good.
Excellent. Okay. Well, if back to Marta and Kevin, though, do you guys want to just kind of give us your Gestalt overview sense, or would you like me to go through this on a sort of section by section basis?
Okay, our overall sense is that we didn't have any other questions to add based on our review of those subparts. There are the 6 subparts. We didn't have any other subparts to add. We suggested for a couple or 3 of them that perhaps we should go into a little bit more detail, prod the applicants a little bit more about what their business models are, to give them a better guidance on how to answer the question. But in order to do that, we have to decide under each concept, what information do we want? Let me just do one quick example. And that is, we asked, describe your proposed legal services offering in detail. That's the Utah. And then it has the subdirection, that's part 1.1. It has the underneath it, it tries to give a little guidance. Who provides the legal services, how consumers will receive these services, and what your service will do for your customers. And, some of the things that I thought in the Arizona were somewhat helpful, where it talks about business objectives. That's part 4 of the Arizona application. And it asks specifically, describe how the business will advance one or more of the following regulatory objectives. Now, we can't really make a suggestion yet until the entire working group decides on what precisely are our objectives. We spent some time at our last scope meeting trying to draft a sort of a objective of the working group with some success, but we had to finally put it off to the side so that we could proceed and work a little bit further on some of the material at hand. But here are the 5 things listed in the Arizona for like these business objectives that they suggested, which tend to bleed into overall objectives of, say, the Sandbox. It says protecting and promoting the public interest, promoting access to legal services, advancing the administration of justice and the rule of law, encouraging an independent, strong, diverse, and effective legal profession, and promoting and maintaining adherence to professional principles. So it's kind of focusing on not just what you want to do, but what are the, I guess, side effects that you contemplate your business proposal is going to accomplish.
Okay.
So,
could you run through those one more time, Kevin? Just my notes are just a little scratchy here.
okay, I'll go a little, protecting and promoting the public interest. That's number 1. Number 2 is promoting access to legal services. 3rd, advancing the administration of justice and rule of law. 4th, encouraging an independent, strong, diverse, and effective legal profession. 5th, promoting and maintaining adherence to professional principles.
I'm typing these into the chat just so everybody can see them as well. And I also put into the chat the actual link to the application materials.
Great. And one of the comments we made in our recommendation for part 1.1 is at a minimum, the instructions for completing the application. I think the Utah has some brief instructions at the end that are probably not necessarily sufficient. But if you use that in combination with the office manual, that is the Office of Legal Services Innovation in Utah, they have a manual that's provided to people who are applying, plus also the Supreme Court Standing Order 15. Both of those, I think, are necessary adjuncts to completing the application to provide guidance to the applicants. So that we, and I think that maybe as we're putting together our application process, it's not just going to be the application, but the instructions for completing the application, I think we need to consider putting together, which is essentially the point that we were trying to make with our recommendation as to 1.1.
Okay, those points are well taken. I do think, to your point, at least one guy's view, I do think that perhaps one of the most interesting aspects of the Utah application are the instructions, the manual they have, particularly when you're dealing with very broad concepts like access to justice. What does that mean? The manuals turn out to be quite important. Okay. All right, why don't we see this to the group? As I look at the at that manual for Utah, we do have describe your proposed legal services offering in detail. And then as Kevin mentioned, this includes who provides the legal services, how consumers will access and receive these services, and 3, what your service will do for your customers. Let me take this in steps. I mean, I appreciate that we can perhaps do a much better job in terms of what does that really mean, but do any of us object to the description and the broad approach to that description represented by what's being done by Utah, leaving open a subsequent meeting in which we might fill in more detail, which I think is the point Kevin and Marta are making quite thoughtfully, I think. But can we agree on this, at least at a high level, as to what the description should include? And to Kevin and Marta initially, since you guys have really wrestled with this more than the rest of us have.
I think Micah has her hand raised.
That's okay. I was just going to ask clarifying questions because I'm not even really sure what the call to action was. So maybe Marta and Kevin, if you guys let us know your thoughts, it might help explain it to me.
Are you asking the call to action for this particular assignment?
Yeah, no, I didn't understand what Tom just said, and I thought if you guys start to, here's the problem. I didn't really understand, Tom, what you were asking us to do, because to me,
let me try again.
Okay, but let me just explain where my confusion is. Without having all of the available information, I think it's really hard for any of us to agree or disagree. I mean, I can read the questions. I think they're very vague. I like the idea of, before I would agree to approve anything, I would want to make sure that we had a lot more specific information.
Okay. All right. Yeah, I think that what I'm trying to do is at least find something we could generally, even if it's general, which is clearly an issue with this set of criteria, but I would love to have some sense as to whether, at least at a high level, we conceptually think these are the broad brush things that should be included in the description we're going to ask of people that want to come into the sandbox. Is there anything big that this misses? Understanding completely that this is a pretty broad and not very specific set of criteria.
Yeah, Tom, the only thing I can think of, it says describe your proposed legal services offering in detail. And then it says include the following.
Right.
And, one point I would say is, point 1 should be, what legal services are you proposing to provide? Okay, so rather than say, describe your proposed legal services in detail, I would make that point 1 of the sub question for part 1.1. Then secondly, who will provide these legal services?
Mm-hmm.
Then third would be, how will customers access or receive these legal services or be provided the legal services? And 4, what do you contemplate your services will do for your customers? I guess I'm saying, why don't we just break it down in the component parts of what we want them to do? There's a description, and then they provide in parenthetical, oh yeah, by the way, in your description, be sure you address these sub issues.
Right.
Yeah, and I think that just say, just step 1, what services are you proposing? Secondly, who will provide those services? Third, how will these be provided, or how will your customers receive the legal services? And 4th, what do you intend your services to do for your customers? which might not be really what they're asking. It might be, what problem are you solving for your customers?
Yeah, I mean, I think your first formulation would be fine. Because you've got basically what, who, how, and then another version of what, frankly, I think in your fourth. But those seem like really basic questions to me that they should answer. How does your fourth fit with your with your first? Just so I understand.
Well, it's really, all I did was I just took the third guidance point in part 1.1 and just tacked it on to the end. And it could be sunk into the first one. What services are you providing? The second question could be, what problem are those services? Do you have you identified that those services are going to be solving? Third would be, how will the consumers receive those services? And then, third would be, who provides the legal services? So maybe move 4 up to 2.
Okay. Mimi, are you getting all of that? On your screen, Kevin, is Mimi sort of capturing your thinking here in situ, basically? How does this work for you? Does this fairly reflect what you have in mind?
I apologize. I didn't have that screen. It got hidden behind.
No worries.
All right, let me just see if I can.
I don't know. We can wordsmith it later, but I think essentially that's the order you want it to appear in.
Does it work for you?
That more or less captures it.
Okay. So I must say I like these. I think this is presumably, and to you, Kevin, and you, Marta, I think this still is subject to further adjustment when we see the Arizona more specific kinds of stuff. But if this were to be the high level statement of what we want, does this capture what you have in mind? Kevin, I think this is your text, but Marta, does this work for you too?
Well, yeah, it is
better.
They're largely vague, open-ended questions, which allows the applicant to describe, hopefully in detail, what they're proposing. One of the aspects that I liked about the Arizona application is that one of the first thing out of the bat that the Arizona applicant has to identify is the name of your corporation or the name of your business. Is it a corporation? Is it a sole proprietorship? Is it an LLC, LLP? You know, it goes through all the different business structures and you have to check a box. If it's a corporation, I would imagine we want to know, where is it? Where are you incorporated? Are you licensed to do business in California? Are you in good standing in California, et cetera? I mean, so there's some preliminary things that we might want to do first.
Yeah, let me just mention that the Utah application in section 1 has applicant info. It's not as detailed as what you have just described, but it says what's your business email, what's your mailing address, contact name, and things of that nature. But it doesn't have whether you were a corp or an LLC or something else. I mean, all of those seem like good ideas to me.
But I mean, as an overall structure, these aren't bad questions. These are information that I would imagine the regulator is going to want to look at. So,
yeah, particularly if you got to do service of process and all that stuff. Okay,
exactly. And one of the one of the questions that's asked in the Arizona application is, who is your agent for service process?
Okay.
So, you know, those are things that are detailed there that I think are important to include on any type of application. And I see Micah has her hand up. She's been waiting patiently.
Okay, Micah, go.
What I like about the Arizona application is it specifically talks about access to justice. And I think we have to have a question asking the applicants how they're going to improve access to justice, even if it's just in a limited scope, like family law or whatever it is. I think they need to make that case to be considered. And the other thing I think we should think about is whether we should ask them if they are funded by any outside entity or organization. You know, what I don't want to see is, and some folks have expressed some concern to me in this regard, is you know, a larger corporation funding a small corporation, or even funding a nonprofit or a foundation that's going to apply to carry out the business of some other entity.
So is your, I don't want to, is your focus then, Micah, on kind of control issues as opposed to capitalization, or what do you, can you give me more detail on what you have in mind?
What I think the risk is if the applicant is funded by someone else. It's just a disclosure issue. I think that you know, we should want to know who's really involved.
Yeah. Okay.
You know, it might even raises another issue. Maybe we should find out early on who's on your board of directors, if you know who if there is one.
Mm-hmm.
I just think we should be learning as much as possible early on so we make the right decisions.
Could I just interject for a second here? If we're doing this part by part, and I think this is, maybe it's better to do the overall application process, and might not even be part one, because some of our discussion is bleeding over into part three, I think.
Yeah, I agree with that.
The benefits and so forth. But a lot of what I think Micah has just raised goes to part 1.2, which talks about the management structure. And in Arizona, they talk about authorized persons. And authorized persons is anyone who first has a financial interest in the company, which they have to disclose that of 10% or more. Or secondly, anyone who has decision-making authority on behalf of the organization. And so I think that would all fit into the Utah question 1.2, which is, after I saw the Arizona, that gave me a lot more ideas as to what part 1.2 should look like.
This is the one to describe the entity business model you want authorized in the sandbox. That's the one you're thinking about.
Right.
Okay. Yeah. Okay.
Yeah, but the Arizona model makes you identify everybody who has a more than 10% stake in the ABS. And it also goes into a lot of detail, asking questions, check the box and otherwise, about has those individuals ever been found guilty of a felony or misdemeanor, material misrepresentation, showing of incompetence, those kinds of things.
Okay. Well, let me see if I only have about 6 more minutes here, unfortunately. But can we just loop back briefly to Kevin's initial text, which is listed here on the screen. What I'm hearing, keep me honest here, guys, is that we do want to at least consider having more detail in Arizona. The Arizona model may provide us some modeling for that, but I'm hoping that we could collectively approve these 4 points, at least at a high level, and then assume and commit ourselves collectively to going back to this list and providing some subpoints, if that makes sense. So do you guys want to do defer all of this until, at least this part of it, until we see and consider more closely the Arizona detailed model, option 1, or 2, can we agree at a high level to some version of this 1, 2, 3, 4 that Kevin articulated? Going once, going twice, what do you think?
I would like to say high level. I know you only have a few minutes left, so I would go with the high level.
Okay.
Yeah. My only concern right now is let's tentatively go with this, because as we go on and see how
I agree with
I
that.
think as we're looking further on in the application, some of those points, we're going to have cross references, and we're going to fall back upon this as we look at some of the later questions.
Yeah, I think that's wise, Kevin. I agree with that completely.
And,
Okay, so
and Tom,
go
if I
ahead.
can just really quickly,
Marty?
one of the things that Kevin and I spoke about yesterday is perhaps we've spent a great deal of time in our discussions in this subcommittee and as a working group as a whole on the Utah model. And we have not spent any time on the Arizona model. And I know there could be an argument that it's apples and oranges, but I think it's worthy of spending some time on the Arizona program and maybe even inviting somebody from the Arizona program to come and speak to our group and give us further detail with respect to the structures that they have in place, their application process, as I understand it, they just wholesale got rid of 5.4 as opposed to Utah's modification to 5.4. These are concepts that I think are worthy of further study, examination as we're doing our work with this in the working group and in our subcommittee.
Okay. Well, why don't we ask the staff to at least see if they can find somebody good from Arizona? I mean, we've had John from Utah, who's just, I think, very, very helpful to us. But why don't we just do 2 things here? We'll circulate the Arizona proposal plus their related manual, so we can all take a look at this with a little bit of time to think about it. But I think what I'm hearing is that, at least for the nonce, Kevin's 1 through 4 work for us, subject to further work that may lead to some sub-bullets, potentially significant sub-bullets underneath each of these. I'll be there in just a minute. Does that sound right? Hearing no objection, is that? Okay. All right, let's go on. I can do maybe like one more thing here. We've talked about what are you offering. We've talked about the need to describe in detail the business model. 2.3 is, why is your proposal eligible to enter the sandbox? So Kevin and Marta, that seems to me as if, the entity needs to tell us that they couldn't provide what they want to provide without violating some ethical or statutory rule, and that's what they've got to tell us. Is it more complicated than that from your perspective? What do you think?
That's a good general statement of what it's asking for, because if you look at looking at the standing order of the Supreme Court, it talks about eligible participants in the sandbox. Well, if you can provide these legal services, if you're a traditional law firm, then you don't really belong in the sandbox. You can provide the legal services as is, as you currently exist. So what this is talking about, identify why you and why your model would otherwise violate traditional
Hello?
conduct rules.
Okay.
Hi, I'm good.
I think would
Mimi,
whoever
you're
is
not-
chatting on
you're
the
not
phone
muted.
mute. Okay. All right. So does that mean that with that understanding, this language, why is your proposal eligible to enter the sandbox, that we can agree that that's what it's all about and we don't need to spend much more time on that?
Yeah, we went into a fair amount of detail explaining where we thought there might be a need to revise the rules. I think we do refer to Utah rule, and in footnote 1 to the memo, we quote
Right.
the 2 provisions of the Utah Rule 5.4. And we think that's going to be probably necessary in California, because lawyers have to know that they aren't violating. If we want, lawyers who are cooperating in a sandbox entity have to be given the green light and know that they're not otherwise violating their ethical duties by cooperating. So it would be, this is separate and apart, I think, from any other revision to Rule 5.4 that we're going to embark upon. I think the people are going to be assigned to various subcommittees to look at the rules 5.4, 5.7, the advertising and solicitation rules, and so forth. So that's something, and the lawyer referral service rules. So that's something we're going to have to take a look at as to whether that's necessary. The other thing is, in California, we have this unique dual system of regulation by both the court and the legislature. And I don't think there's any way around it. You got to get the legislature involved and make some amendments. Only the legislature can carve out exceptions to the statutes, and the unauthorized practice of law. The media statute is the statute, sections 6125 et sec of the Business and Professions Code. That's where the prohibition is. All that the rules of professional conduct do is they tell lawyers you can't assist anybody engaging in the unauthorized practice of law, other people who violate 6125. You, a California lawyer, don't violate it because you're licensed here in California. So you
Right.
can't do it. But
Okay,
if you
so
assist somebody, you violate it.
yeah, I'm going to have to turn this over like momentarily to Rebecca, but just back to you, Kevin. Is this language, why is your proposal eligible to enter the sandbox, enough, or do we need to list the California rules we think may be California rules and legislative text that may be most significant here? Do we just need to drop a footnote? Please be advised, some version of that. Again, I'm just trying to find something we can agree on, but I don't want to cut against your wisdom on this. What do you think?
Yeah, I think that we might want to identify some of the rules that could cause problems, or at least refer people to rules of professional conduct. Because if you look at the types of service models that Utah has identified, nearly all of them, the vast majority of them have lawyers involved in providing legal services,
Yeah.
at least to some extent. Those lawyers are going to be running afoul of the UPL rules if they are working in concert with non-lawyers to provide legal services, where the non-lawyers might have managerial or supervisory authority over the lawyers. That's all I'm saying. So
okay, no. I think there's lots of wisdom in that. So let me play this back to you. If we were to go with this language, tell us why you need to be in this sandbox, and then dropped an explanatory footnote or some explanatory text to be written and approved at a later date. Does this language work for us at a high level? Again, the language is, why is your proposal eligible to enter the sandbox?
Well, once again, I think it would be really helpful to have the people who are trying to answer this question have access to something akin to Standing Order 15. So
Okay.
you could make a cross-reference to Standing Order 15 or whatever authorization we're going to have here in California, which I assume
right.
would be a joint legislative or
Sure. No, makes completely good sense. Let me see if I can impose, because I am about to turn it into a pumpkin here. Could I ask you and Marta to do that kind of text, at least preliminarily, and then we'll just roll this over till next time. And then Becky, I really am turning into a pumpkin. I'm going to miss my little trolley over to this wedding event. So I'm going to hand the baton to you if that works.
Sure. Have fun.
Okay. Bless you and yours. Thanks. Thank you all. I look forward to our next conversation.
yeah. Thanks,
Thanks,
Tom.
Tom.
Bye-bye.
Enjoy your evening.
Thank you. Bye.
Bye-bye. Okay. So I think we've made in some ways some important progress at the high level, and also in the idea that the California application is going to be more explicit about the kinds of details that it wants. I wanted to when I look at Kevin and Marta's memo, starting at about 1.4, so target consumers and service models, my sense is that you don't have a lot to say about those parts of the application at this point. Is that correct? Or is there something that you want to lift up for us from your consideration of those later parts?
Well,
So if you look at 1.4, we couldn't really answer that question or speak to it until some decision is made as to what areas of legal services. Is it going to be all legal services? Is it going to be particular areas that are linked to the California Closing the Justice Gap report? And I don't think we've made that decision yet on the working group. Once we make that decision, we can go back to 1.4 and try and address it in more detail.
agreed. And in particular, on the Utah application, it's for 1.6, it is, a check the box, the first part is kind of a check the box place. The first one there is accident and injury. I don't know that's necessarily an access to justice issue. I think our group can agree that PI cases, people have access to lawyers in those areas. Maybe there's other issues here that do raise concerns and would closely tie into the Closing the Justice Gap study that has been done in this state. So we do have concerns with respect to that, those portions of the application of the Utah application, but we frankly didn't know what to do with it based upon the state of our discussions today.
Gotcha. Yeah, the content of those options will be determined by a different conversation, I think.
Right, exactly.
So are there further thoughts on this first section of the application from anyone? Something that ought to be in there that isn't?
Well, I guess just turning back to the Arizona application, I think that's the only kind of caveat that I would have, that I think it really does, we should look beyond Utah to see what other state is doing, what Arizona is doing, and see if there's anything there that we'd like to study in greater detail for its application in California.
Okay, great. And I think staff are working on getting somebody who can give us a presentation on that. Going twice. Going 3 times. All right. Thank you. So then I think if everyone is amenable, we can move to the next section of the application, which is risks. And I think David and Micah were point on that. Do you want to just give us your thoughts on that?
For some reason, I can't see David on my screen, so
He's there.
He's there. Okay.
Yeah, I'm here.
Okay. Are you gonna share your screen? Are we allowed to do that?
Yeah, do we have the power to share a screen?
Yes, you do.
Great. Yeah, so Mike and I worked up a document. It's a Word document, and I'll show it to you in just a second, but it essentially takes part 2 of the Utah application and then fills in and layers on some additional questions. And they're highlighted in, I think, green, if I remember, turquoise. And so I think what we should do is just put it up on the screen and everyone can take a couple minutes to unpack it. And I think that's going to be the best way to organize conversation.
And I'm happy to talk through some of them. I believe the color is teal. David.
Teal, yes. Sorry, Micah. Oh my gosh. All right. So is that coming through for everyone? Have I successfully shared?
You've shared.
Yeah, could
Yeah,
you,
if you could.
could you
Zoom in.
increase the size of the font?
Sure. How do I go about that? Anyone?
Go up to view.
Probably just down here on this side. Right?
Yeah, there you go.
Does that seem good?
That's much better.
I guess I worry if I increase it too much, then maybe it actually isn't all in one place. But is that still good, everyone?
That's working.
I
Great.
think so.
Much better.
So I know David has his own thoughts about the particular questions that he included. I'll just jump in and let folks know that when doing this analysis and thinking about, what questions we can ask and what the risks are that I would be afraid of if I were sending someone, to an application, for example, assuming someone participated in the sandbox and then, had been approved and had developed an app or whatever. I was guided back to the moral character process for the lawyers. And so I printed out all of the admissions rules and everything the State Bar has on the moral character process and the factors that those investigators and decision makers take into account when they're deciding whether or not someone has, the appropriate amount of good moral character to be admitted to practice. And I just kind of tried to synthesize those factors, because I think that if there are any problems with any of the participants in terms of, folks associated with these companies or entities that would keep them out of the ability to practice law because of the moral character process, I don't think they should be included. So I thought we would want to know whether or not they had any problems in those areas. So that's kind of generally what a large amount of the sub questions are based on. And I think also it's just geared towards finding out as much information as possible. We still don't know how long the sandbox will last or what it'll cost the State Bar or whatever entity gets created. And I think we're entitled to this information and we want to make sure we have the best applicants possible, weed out any issues in advance.
Can I ask kind of a conceptual question? David, were you going to say something? I don't want to interrupt you.
No, I wasn't. Go for it. I thought maybe we were gonna. I want to make sure people have had a chance to read through it. I think it might be hard to really focus on it while one of us is presenting at the same time. So maybe it might make sense to pause for 30 or 45 seconds, even though that can be really awkward on a Zoom call where everyone's just silently reading something. But that might make sense just to make sure everyone has had a chance to unpack this before we start to go into questions and/or conversation. I'll leave it to you, Becky, as the fearless chair here to decide when enough time has elapsed.
So it's terrible not being in a classroom. You can't do the eye contact thing when people have stopped looking down. I've lost all my cues. Are folks comfortable moving ahead? Okay. So I'll go ahead and ask my conceptual question. I mean, I think part of what's kind of wonky about the way the working groups work is the specific content of those risks is being developed by a different group, right? So we're going to get that from the SAGE group, I suspect. And so then we're thinking about, without knowing necessarily what those are, how to ask about risks in the application. And my conceptual question is sort of the stuff about disclosures about your own past conduct in the Utah application is at the end, in a sort of like describe whether you've done these things section. Could you say something about, I mean, do you want it in the risk section and why, I guess?
Well, you're talking about section 4.
Yeah.
Yeah. I mean, it could, you know, I have comments and edits on section 4 too. So, you know, I went through all of these sections and came up with additional questions and thoughts. It could be anywhere. I mean, really what I was looking for was what are the risks to the consumer? And what are the risks to the sandbox or the regulatory process? So, you know, I guess it depends on how we define the risks and who's taking the risk in terms of where it could be. But I am so glad that we made it larger so all the typos could be seen quite clearly. So I'm happy about that.
I have a question, and maybe it's not appropriate for this section, but in general, someone who violates academic honesty and code of conduct isn't necessarily going to be honest on this application. So how do we verify that at some point?
You know, I think it's a great question, and there are investigators. Maybe that's not the right term. Someone who's on staff would be able to tell us what they're called. But when lawyers are applying, these things get looked into, and it's quite a long process. I think the shortest amount of time that the moral character application process takes is like 180 days or something. So, you know, do we do a good job as a state bar weeding out lawyers with moral character issues? Are we going to do a great job weeding out applicants who are, you know, maybe also have some moral character issues? I don't know. It depends on how we structure things and how seriously we take this type of stuff. I mean, I personally don't think we should, you know, in another section, it talks about, you know, lawyers who have been disbarred. Oh no, it doesn't even talk about that. I wrote that down. We should be asking about that. But, you know, I think we have to decide how we're going to ferret out some of the bad apples.
Thank you.
A question I had to sort of build on that a little bit is I've forgotten whether the larger group had decided this issue or whether SAGE is looking at it. Weren't we going to require the applicants to go through a moral character review? And if that's the case, then I can see some of these questions going into that analysis as opposed to being a screening question used here. And also, at least in terms of the Utah application, the way I see Section 2 is Section 2 is sort of forcing the applicant to figure out quality control practices, reduce risks to consumers and clients of these services, just to make the applicant think about those things and then articulate them. So just, those are my two questions.
I like that framing. So let me try to frame up, I guess, 3 different types of questions we could ask in this section. And maybe that would be helpful as a way to move the ball forward a little bit. So you can think of 3 types of inquiries we might have here. One would be, something like what's in 2.1, which I think of as like a substantive inquiry. It's like it asks the applicant to try to highlight for us forms of harm that they think could result from their provision of services. So that's certainly one type of question, and I think that's absolutely important to have in this in this part of the application. And I totally agree with you that it's almost like it's almost demanding a level of reflection on the part of the applicant to actually think about it. So, but that's the first type. The second type would be questions about past violations, and they're actually status-based questions in a sense. You're actually trying to figure, it's almost a form of proclivity evidence. Did this person commit violations in the past, and therefore might we want to provide more, well, bar them entirely, or alternatively might we apply more scrutiny to their applications. That's a second type that could be in this section, but as Becky noted, it could get kicked to the end and could be in a separate section, or it could even be rolled into a moral character type inquiry. The third type is then like process questions. And there we're asking the applicant to tell us what kinds of procedures and protocols they're going to have in place, and they intend to have in place in order to avoid some of the substantive harms then that they have articulated in 2.1. So I don't know, is that useful? That's like kind of three slices, three types of inquiries that we could put them through in this section. And I think probably all three of them need to be somewhere in the application, but I'm totally agnostic as to whether, say, the moral character type questions or the proclivity evidence type questions get pushed to some other part of the application.
Yeah, and the other concern I have too about the status questions that are in 2.1 is obviously that for some of these bodies, there's going to be multiple applicants within an application, right? And so so that would also, I think, weigh in favor of maybe spinning this off into a different individual section that each applicant fills out, or something like that.
Does anyone else remember? I don't remember hearing that there was going to be a moral character type of analysis. Does anyone? I'm looking at staff. Maybe Randy, you're the only one I can see, so. Do you remember?
I don't.
I can see Andrew too.
Yeah,
I don't believe there has been a formal recommendation that as part of the eligibility criteria, that only those who satisfactorily pass a moral character investigation would be admitted to the sandbox. But I think it is something that is an absolutely worthy part of the discussion in terms of what should be the process for considering the applicants. We do have moral character for lawyers, and these folks will have the same clients, consumers will be reposing the same type of high-level trust to these folks with things that are very important to them, whether it's financial or otherwise. And the moral character process is a longstanding mechanism for assuring that the provider of the service is not just competent, but honest.
So
I think it's worthy. Kevin has his hand up too.
Yeah, I just wanted, what it seems to be, as David ably summarized those three types of harms, or three parts of the question that might be asked. I think forms of harm, that would be question 2.1 as I read question 2.1.
Yeah, that's right.
Process questions are question 2.2. And then 2.3 just says, what are your complaint mechanism? This doesn't contemplate at all past violations, which I think most would be is applicant background information in making a determination. So 2.1, I think it's been said that they want somebody to think hard, reflect about what types of harms might arise because you've come up with this new method of delivering legal services. And it sort of leads into 2.2, because if it's consider the process where you're a you're providing legal services through lawyers, but the lawyers don't work for you. You're matching lawyers and clients. Then what quality control are you going to do? Can you see where, well, gee, I might match up a client with a lawyer who's incompetent. How am I going to guard against that? And so forth. So there's going to be a little bit of overlap in it. But I think they're valid questions. I don't think that we can necessarily come up with a better way to carve up the turkey. I think these are pretty good questions or pretty good groupings to ask.
I have one suggestion for a further turkey carving, which would be, it seems like maybe under 2.4 or as a 2.4, we could ask some of the check the box sorts of questions that are being proposed and that are in the Arizona application as well. For instance, whether they have insurance, that's a check the box sort of a thing. That's not going to require a narrative response of any kind. And so I wonder if we could kind of load those into a miscellaneous 2.4 as a way to capture a few more things that I think are in that Arizona application and that have been discussed and that we've even proposed in some of the teal highlighting as well. I wonder if that's a good way to organize it.
I like that. I think that's an easy way to do it.
The Arizona application does have a check the box portion of its application that goes into the background information that doesn't look prospectively, but looks at their background and whether or not they've been charged with a crime, convicted of a crime, their licensure of any kind has been revoked, suspended, and it's all check the box with if you've answered yes, please provide further information. So I think you're right, David. This could be a very good place to put a check the box kind of insert into the application process, so the regulatory office that's reviewing it can see their background information and their disclosures, and do it for each of the persons that are going to be involved in the organization.
So I'm doing the bad thing of typing while I'm not looking at you. Are there further comments on this, or could I propose that we kind of have an agreement to go back to David's original formulation? So this section, so somewhere on the application, perhaps in this section, we want to know the substantive, what are the possible harms this entity thinks it could create? We want to know how they're going to avoid those substantive harms. We have a set of facts about maybe harm reduction procedures like having insurance that we want to ask about somewhere. And then we have a set of facts about different kinds of past violations or past behaviors that we want to ask about somewhere. Does that sound like an honest representation of the conversation?
And don't forget the complaint process.
Yeah.
That they have to describe.
Yeah, I think that sounds great, Becky. And I think that complaint process can just be part of the process question. We could break it out and make it 2.3. I could also imagine it being part of 2.2. I mean, the complaint process is supposed to provide information to the regulator, but it can also be seen as a way of providing information to the service provider. We would hope that our service providers are in good faith, keeping tabs on these sorts of things, and are open to changing the way they do things, even before a regulator or some external, oversight mechanism tells them to.
Okay, so we got progress there. There's an issue that came up that I want to raise at the end, but I want you all to have a chance to tell us any further thoughts you have about the risk section and what we should be asking.
Well, one thing that's been nagging at me, and I don't know that it's our job to articulate or try and preemptively solve this, but I can't remember who it was, if it was Kevin who said, maybe they'll assign someone who's an incompetent lawyer, but and that's obviously a risk and important. And what I keep grappling with is, you know, the attorney-client relationship when you represent real people is really based on chemistry, and you know, your relationship is years long. You really get to know the people that you represent. How, you know, what about personality conflicts if you're just being assigned a lawyer or a paralegal or whatever? What kind of remedy or how can that be addressed? Or at least how can we get, maybe a better question is, how can we get the applicants to start thinking about that dynamic in the beginning? Is this way too touchy-feely for like what we're supposed to be doing?
Well, I think it raises an important question that will animate a lot of our disagreements probably, which is how much of what happens to the consumer do we want to leave up to choice and markets, and how much do we want to try to structure through regulation? So, you know, one response to your point, Micah, is if I don't like this one, I can fire him and get a new one, which is what I do now. Like, I've fired lawyers before, you know, so, and also not all relationships are going to be long-term, right? Some of them are going to be very discrete services, unbundled. And so that wouldn't be the same kind of issue that it would be if you're the family lawyer and you're working with this family for 25 years. But it does raise an interesting question about sort of what is the scope of what the sandbox would regulate, and what do we leave to choice and markets? So I want to raise an issue that I think is going to be, we're not going to resolve it today, but but first, David and Micah, anything else you want to highlight for us about this section?
Not for me.
I might just say one more thing before you turn to what you're going to, Becky, which is that as I think about how this could be structured and what this will ultimately look like, especially once we add a bunch of things to it, I do think that there is a risk and a concern. And when I try to articulate, I always think of this, the canon of statutory construction, you know, expressio unius, right? If you articulate a whole bunch of things, then those become the exhaustive list. And in fact, that should exclude and preclude consideration of other things. And I think if you put in too much check the box stuff, and if you describe, if you provide too many examples of types of harm that you want them to articulate, the applicants, that is, then you actually crowd out some of their own independent thinking about what types of harm that they think might come to pass as a result of this new delivery model. And so I guess I just think that's something we should be sensitive to. And maybe there's a further point to be made here as well, which is that I think you can spend a whole lot of time wordsmithing an application like this, but the reality is this is going to be an iterative process. I'm positive that's how the Utah system works. I mean, this is not just a one-off thing and you rest on your papers and that's it. I think there's probably a lot of engagement and back and forth with respect to any particular applicant. And so I think we should keep that in mind. I think keeping it high level and avoiding too much detail and too much check the box stuff trying to avoid that is probably wise. So that's the last thing I would say.
That's a great point, David. Thank you. So I want to raise an issue that I think we should talk about. It's come out of precisely out of this conversation. I don't think we should try to resolve it, but it has to do with the independent verification of information, for example, like the sort of personal background check that is being proposed for people. What are folks' thoughts about that? Because that would be part of the application process, right? What would you want this sandbox to do when it gets that information about past conduct?
That's an interesting question, because I was thinking about that very thing. Is the regulatory office going to have like a rubric that they grade people on? or applicants on, or an application process on, like maybe, you know, it's a really great business model, but one of their guys, you know, had a DUI when, you know, 10 years ago. I don't know. I think that's I don't know how to answer that question, but I think it's something that this group collectively needs to address and consider as we're doing our work, because, you know, do we want to throw the baby out with the bathwater? And where do all the check the boxes and the risk assessments, how does that get all that information get synthesized into whether or not an applicant gets tossed into the sandbox or not?
I think that it should be the same standard that the folks in the moral character office, if that's where they are, use. And essentially it's like not one offense is, you know, greater than the other. It doesn't mean if you fail in one area, you're going to get kicked out. They look at the facts, they look at the circumstances. For example, you know, with the, I think there's substance abuse issues, drug and alcohol abuse. They look at how long ago it was, whether it resulted in something like a DUI that you would have to report if you were a lawyer and is considered moral, you know, question of moral turpitude, that kind of stuff. So it's kind of like they take all of the information and make decisions. It's not like something where they score, well, you had, you know, one court order violation over here, that's worth 10 points versus, you know, a wet reckless when you were 21, that's worth 100 points or whatever. And you know what might be helpful is maybe some of the folks who work in that department can come talk to us about how they take all the information in, how they do their investigations. I mean, obviously, we don't want to throw the baby out with the bathwater. There could be some great folks and some great ideas, but I don't think we should lower the standards. If people are going to be performing legal services and lawyers have to go through this process, so should corporations who want to participate and potentially practice law.
So let me turn that question, what you said, around a little bit. So I think I would, as a person who
looks at evidence of a sort of social scientific sense for a living, do we have any evidence that the moral character process works? That is, do we know that the lawyers who end up practicing on the other side of that are better than the lawyers who might end up practicing on the other side of a different process that we could design here, right? So is there a better way to achieve that goal that we could have ideas about? Because obviously preventing harm is the point, but you know, are there other ways we might do it than that traditional moral character model?
I mean, I think you should ask the state bar folks that, you know, there are a lot of people who have trouble with the moral character. There was actually just an article in the Daily Journal about how that the state bar has issues with the MPRE. Did anyone see that? I can circulate it. I think it was like 2 days ago in the Daily Journal. But that's a great question.
So Becky, is your question about how we verify the violations, or is your question whether, you know, in lawyers' terms, having committed violations is probative of, you know, the quality of services you might provide, or in social science terms, you know, is there a causal relationship between having, you know, could we say there's some sort of relationship between having committed a violation and, you know, likelihood of being a crappy provider going forward?
So my question was the second one, and then we could think about the issue of verification. But I was just curious, as we were in this, you know, as we were sort of taking the moral character model from lawyers, if we thought we could do it better. Since we have an opportunity to do it better, did folks have thoughts on that?
I'd like a little input maybe from Crispin Passmore. on England, which seems to take a slightly different risk-based approach. I mean, they do look at backgrounds of people, but I don't know what standard they apply. With the moral character application here in California and in other jurisdictions from my talks with lawyers who get involved in the process in other jurisdictions, the focus is largely on crimes of honesty, moral turpitude, and so forth. That seems to be the real focus, that if these entities or the people who are going to be participating in the process, the sandbox, are going to be handling money, handling client money, then we want to have some assurance that they are going to be, dare I say it, relatively honest, if not absolutely honest, maybe compared to your typical run-of-the-mill people. So I don't know. I'm curious as to what England has done in this regard. But I note that in Arizona, and I mentioned this to Marta going over the Arizona application, it seems like they just copied and pasted their moral character application into their application for ABS. They have like, I think 21 questions about past conduct in which you might have engaged. You know, have you ever declared bankruptcy and so on and so forth.
And I think if we're looking for, the best way to move forward on some kind of analysis, it might make sense not just to talk to the people at the state bar who administer that process, but to some of the lawyers that that represent clients in moral character analysis and cases, to see, is there a better way that they might have, that they see that might accomplish the same thing in a more effective and a better way, because it's a very time-consuming and costly process right now.
Yeah. Could I throw out an idea here? The way I see the Utah application is that it's sort of asking the applicants to provide as much information about what kind of model they're proposing, and of course, like we talked about earlier, the risks associated with that model. And maybe this should be like a two-stage process, right? So the first application has to go through about what your business model is and what the risks are, and then if you make it through that pass by the regulatory body, then you ask the individual questions, because again, I can see a lot of these applicants having multiple, a lot of these individual, single application having multiple applicants within them, right? And that way you have maybe a staged process, as opposed to throwing in every single question you could possibly ask into this one application.
What do folks think? That's within our power. It's within our power to make recommendations on that. So,
well, that's an interesting concept. However, I wonder if the applicants will be misled by the process, unless that's fully disclosed, that it's a two-tiered process. You first have to get through the first gate, and then if you're past that gate, you go on to a deeper dive into the background of the people that are going to be running the show.
Right.
I kind of like it having an upfront analysis, because I'm more of a, here it is, transparency all in one shot. Give us everything you want us to know, and then we'll make some decisions. And then again, I would imagine it's an interactive process where questions are then follow-up questions, and that you engage the innovative office or the sandbox regulator, whoever it is going to be engaging with the applicants as they're evaluating it.
Well, what you could also do as well is you could, in this stage one application, ask a question that everybody agrees, without a doubt, that you should not be participating here. Like, have you ever been convicted of murder, or have you ever been convicted of a felony, or have you ever been disbarred? You could have that in the stage one. That would at least screen out some folks initially. But then if you want a more detailed review of the individuals, well, why don't we first see what your business model is, and then if it looks promising, then we'll do that more deeper dive.
It seems to me that lawyers go through that. They've got the bar exam and they've got the character and fitness. They're separated.
Yeah.
And you can't get to the in-depth character and fitness unless you've shown that you can pass the bar exam, or I don't know exactly how the timing works, but they're separate processes.
So I think Neil's two-stage suggestion is just a formalization of how I thought the process would work in any event. So, it is clear that some of these check the box things will preclude entrance outright, right? It's just an on-off switch. But that in other instances, a set of violations, a single violation, a set of violations, a set of minor violations might draw additional scrutiny at what would then be a formal second stage, or could be an informal second stage as part of an as part of an iterative process. But I don't know. I guess Neil, I like it. It sounds like, as a matter of fairness, I think due process is too strong, but as a matter of fairness, it might make sense to disclose to applicants up front that this is a two-stage process. But again, I guess as you described it, Neil, that's kind of how I thought it would work in any event.
Yeah, I would just not want to see any absolute decision in the first stage that, based on somebody's, say, criminal background, or the fact that they might have been disbarred 15 or 20 years ago. And there's been a passage of time that have led an exemplary life in the interim. I know I've had students with a criminal past, and I'm a little bit concerned that they might want to come in and they have a proposal to offer legal services to others, say, recently released convicts. I wouldn't want a decision made at the first stage that would preclude them from perhaps getting involved in those types of services, where that might be one of the reasons why they went to law school in the first place. So I would be real hesitant as to what are the things that are going to be absolute, determining what would be an absolute prohibition on participation.
Just to kind of add something.
If you're looking at felony convictions for things like drugs, those are not equally distributed across populations in the country. And so when you have an automatic bar, it's going to have a disparate impact on people of color, for example, and would make the sandbox whiter than it might otherwise be. So I think it's a great point to try to avoid as many absolute bars as we can. So what I'm hearing on this section is that we have these 4 different kinds of information that we want to ask about, that we're going to be careful about having lots and lots of check boxes that sort of define the world. We're going to try to find a good balance between that and asking more open-ended questions. And then there's a wish for more information, both about Arizona, but also about England, and also about the moral character process in the California bar, both from the people who manage that process and then the people who contest that process, basically. Does that sound right? Okay. Well, I think thank you, David and Micah, that was great. I think we can move to benefits, to a cheerful section. So Toby and Patricia, do you want to sort of give us you wrote a memo, but do you want to give us your highlights?
Sure. Do you want me to start, Patricia? Okay.
Yeah.
This is the other side of what we've been talking about. This is, how is what you're doing going to do good for society and for the clients and the like. I think what our thought was that the questions they ask are fine. They're probably the right questions, but maybe a little more detail. The first question says, describe how your model will provide three different things: higher quality, more cost-effective, and more accessible legal services. And I think where we came out was that it would make sense to divide those and make sure that all three are addressed, so that if the proposal is in fact going to be cost-effective and higher quality, but won't necessarily be more accessible, or if it's accessible and quality but not necessarily cost-effective, that ought to be highlighted, so that somebody's going to have to address each of the three pieces. And then on 2.2, trying to remember what we said. I think that one we were comfortable with the way it was, relatively. I know I've got it here somewhere. Too much paper. There it is now. Anyhow, yeah, I think we were generally okay with 2.2, and 2.3 goes back to what we were talking about in the other, of what kind of complaint process there would be. Anybody has our draft handy? I'm having trouble locating it among all the papers on my keyboard.
Yeah.
Tricia?
I'm trying to pull it up here.
So,
Yeah.
what I'm hearing is that the recommendation in terms of substance is that three benefits to ask about are cost, quality, and accessibility.
Yes.
So folks do we have general agreement on that?
My only question is they're stated, it's sort of a picky question, but they're stated relative to what? They're saying higher quality. Well, if they're not getting legal services now, then they're getting quality legal services. Yeah, it's going to be higher quality by default. So I'm just not sure what the modifiers are supposed to mean, other than just saying that they're providing quality, cost effective, and accessible. I mean, what are they more than supposed to be for the targeted consumers?
In one of our discussions, David brought this up. He was bringing up the example of Mill's utilitarianism, like cost benefit analysis. So we do need to have a definition of what is the benefit, and then I'll agree on that. If we have no services and we offer services, but more harm is being done, that's not going to be really a benefit. So I don't have an answer for you, except for that we need to come to a consensus on what we agree as a benefit.
I guess I think Kevin's right that maybe we drop the modifiers there and just say provide high quality, cost effective, and accessible, and what they need to address is how are you addressing quality, how are you addressing cost effectiveness, and how are you addressing accessibility, as how they respond to what are the benefits to consumers here.
I had a question about the accessibility component.
Yeah.
And just forgive me if this is obvious to others, but like accessible, how? That the provider has enough resources to provide their services to whoever comes to see it, accessible through ADA regulations. I just wasn't quite sure what was meant by accessible. Or was it all of those things?
I guess my sense is it's an open-ended question, and let them explain, you know, who's it accessible to and how. So if it's, you know, totally online and that's the only way of accessing it, how does that restrict access for some people and allow it for others? If it's a physical, you know, you've got to come into the office. Where's the office? Is it handicapped accessible? Obviously, that's not going to be accessible to people in other geographic parts of the state. But it will be, you know, if it's in a neighborhood that's underserved, it might provide accessibility that to people who otherwise wouldn't have accessibility to a law office because there's no lawyers there, or in a legal desert, particularly like in the rural areas of the state.
So would that require a standard to be articulated that the applicant would have to meet in order to qualify in the accessibility prong, or is it more back to what you're saying? It's more open-ended, just so that accessibility is being addressed in some manner by the applicant? That's certainly my sense, is that we want them to think about it and to tell us what their thoughts are about it. I don't think we can or should have a, you know, if it doesn't check these 3 boxes, they're out. But it's something we want to make sure they've addressed, and that the body that's assessing these things will say, okay, you know, you've made a good faith effort at addressing it here, and we think it's helpful. It's going to benefit consumers in some way. And maybe they don't address. And just for others, just make sure it's obvious. I mean, these questions are coming from, I am employed by a regulator, so I do have the regulator point of view when I'm asking these questions. I could see cost and quality being, for me personally, a little more objective. Accessibility, I see several definitions which could fall under that term, and I was just curious if we could maybe flesh it out a little.
And I was wondering, when you asked about accessibility and ADA requirements, aren't we having, or don't we have a choice on which platform we have build, like which vendor will build this platform? So certain things like screen readers and ADA compliant platforms can be built within that system, right? We'll have a say in that. So my understanding, and maybe I'm wrong, but we'll have the system in one system that everybody's using, that Sandbox environment. So the element of ADA requirements needed to build that platform would be the onus would be put on whoever designs that program, and that level wouldn't necessarily have to be the person who uses the platform. It's the consumer that would have access to something that we provide to the consumers, rather than worrying if the lawyers are giving that part of the ADA requirement. There's other elements to it, like you say, if the person needs to go physically there, if they're like, whatever, those are examples, screen reader, or just any kind of, if that makes any sense. We have,
does. I mean,
okay.
We could make a requirement. I think it's still open for the full group to decide that any applicant comply with ADA requirements, but I think it would be up to them to determine which, you know, software they'd want to use, so long as it complied with, you know, ADA regulations. I guess, I don't know if Becky knows, or maybe we could ask John if others are as interested. I just wonder how Utah evaluates this component, accessible.
Yeah, could accessible just mean access, as in access to justice, is what they're trying to get at, rather than doing a deep dive into the ADA? That's really what they're just trying to ask. Not very well, I might add, but that might be the question that they're trying to get at.
Sure.
Because it's talking about benefits.
Yeah, that's how I took it to be as well.
that makes perfect sense now. Thank you.
I would like to just, I agree. We do need to define that, but I myself have had to use ADA modifications. Right now, we're using transcripts because it helps me. Sometimes I can't fully comprehend what people are saying because of the various noises. So I want to advocate a little bit more and say that those slight modifications might not make a difference to some, but in terms of legalities and access to justice for those that need modifications or accommodations, that becomes important for them to fully be, to be on the same footing as others.
Mhm.
So we think the three benefits are quality, cost effectiveness, and accessibility. We're going to punt on the definition of accessible. Are we okay with that? We're going to let it read a response.
Yeah, I think I'm the one who raised it. I apologize for taking up so much time. I get light bulb went off in my head when Kevin described it. So maybe, we could add a word or two just to specify what we mean by accessible, but I don't think we need to go into a detailed definition, speaking for myself personally.
Okay, so
So maybe to follow on Andrew's comment, maybe it's because accessibility is a buzzword. Maybe you just say impact on access to legal services instead of using a word that has potential technical meaning.
Yeah, or simply increasing access to legal service, whatever.
Yeah.
You don't have to harp over it here, but I think I get it now. Thank you.
all right, so we have a pretty good agreement on that aspect. Toby and Patricia, was there more that you wanted to raise up for the group?
No, this is good, thank you. Okay.
Yeah, I think the 3.2, change it to California, but that's a pretty obvious one. But 3.3 is a policy question. Do we want to adopt the Utah model of shovel ready when if it's approved, it needs to be ready to go. Because if it's going to benefit society and we spent all this time reviewing it, we don't want to say, okay, you can start up a year from now. We want you to be ready to go. So I think that makes sense to have that kind of requirement.
What do other folks think about that? I mean, the reality is that we basically waive it.
Is that right?
Because most people are not shovel ready, but.
Oh,
yeah,
well.
I thought on John's initial presentation, there was some discussion that an applicant could be approved and then there's, a several month grace period for them to get everything together.
Yeah.
Yeah.
Well, if that's going to be the rule, then we probably should have not have a question that requires that it be immediately, have immediate implementation.
Maybe make that the first question. If not, then,
Tell us when you're ready.
yeah, apply it some other time.
It becomes a chicken egg issue, and the reason we waive it is, let's say you have to get a substantial amount of outside investment in order to do whatever you're going to do. Those investors are going to want to know that that activity has been approved before they commit the money.
Yeah.
And so it's a way of giving them that.
Well, so maybe
when they go out to fundraise.
So maybe the question then, rather than will it be ready immediately, is once we give approval, what's how much time will it take and what process do you need before you can actually start delivering services? So that we have a sense that it's ready to at least move forward, even if it's not going to start tomorrow. But if it's going to be 2 years, then maybe come back when you're a little further along.
So I'm wondering if maybe the concept also involves the idea of proof of concept. And so maybe it's not just the timeline to launch, but also, do you have just an idea, or do you have something that actually has been tested? And as Becky says, once you have the financing, you can switch gears into higher level production. But are we really looking for applicants who don't have a proof of concept yet? I guess is my question.
Great question. It goes to the core of the innovation aspect of the project.
Yeah.
So you have an entity, for example, that's providing services in England, Wales, or some other country where it's permitted, but it's not permitted in California. So it's a proven concept, but they don't have the financing to expand their services yet here in the United States. So you should still be able to approve the application pending financing.
That makes sense.
What if, so there's an idea in Utah that hasn't been submitted yet, but it is to take Spanish-speaking grandmas, basically, it's the Abuelas Project, and train them to be assistants to people who are going through eviction processes. They'd be in-court kind of navigators, and they'd be able to give legal advice if they were within the context of the sandbox. So that there's no program that exists like that in the US, right? But if someone came in and they said, well, we can show you evidence from jurisdictions where this kind of practice is allowed that it works, would that count as proof of concept? So that specific model has not necessarily been tried before, but it's like a lot of other models that have. Would that satisfy that kind of idea?
I think it would. But I think there has to be something more than, oh, I've got an idea. Let's kick it around, and then if it worked, if you approve it, then we can start thinking about how we're going to implement it and how it's going to, I think it needs to be further along than just a concept, a basic concept, but something that has preferably been proven, but if not, at least by analogy has enough certainty to say, yeah, this is something that will likely work in a reasonable amount of time. Followed by the monitoring afterwards to make sure it is in fact working, which is a whole nother area.
Does anyone want to say a word in favor of no proof of concept?
Sorry, I couldn't hear you. You're cutting out a little bit for me. I don't know if people are having that issue.
So let's say somebody comes along and they propose something we can't even imagine. And so they wouldn't have a proof of concept. Would this criteria preclude that? Something so innovative, we can't think of it. Is that a concern?
I wouldn't think, I mean, conceptually, we're building a sandbox where if it ticks the other boxes, then it should be able to reasonably pass muster, right? I mean, if it's it's a lengthy application process, we're looking to see whether or not it's going to be, if that concept, regardless of whether or not it's been operating in other jurisdictions, is going to be promoting justice, serving an unmet legal need for a target audience, right? Theoretically. So I would think it would.
We could have a this will blow your mind tick box.
Yeah, no, I think if we're talking about not having the, shovel-ready requirement that Utah has but waives, but still we want people to address in the application, and it's something that is a part of the consideration, not a yes or no, but a part of the consideration as to whether this should go forward. If it's, something nobody's ever heard of, but they can explain how it in fact can work and might be effective at accomplishing the goal, that wouldn't preclude it. But if it's just, here's a wild concept, let me throw it out there without a lot of thought, then I think that might be saying, wait a minute, you need to give it some more thought before you go forward.
Yeah, if it's a thoughtful wild concept, then it could be accepted. But the thing is, this is going to be a holistic application. I mean, it's not going to be decided on one part. So it might seem to be a way out idea, but there's also going to be all the issues that we previously discussed that David and Micah put through about risk analysis.
Yeah.
So we're going to be able to make a determination based in part on the risk analysis, the background of the people, and so forth, the proposal, what the need is, any relevant argument that they're able to make based on the evidence that they've been able to put together as to whether this is actually going to do the trick. So yeah, I see no problem with accepting something that we never thought of. Isn't that what innovation is all about?
Absolutely.
Don't we all wish we had thought of Facebook? I would have retired though by now if I had.
I think that sounds right, because when you say holistic application, I think it's pretty clear that if someone just has an idea and all the other parts of the application are basically TBD, we're not quite sure what those risks are. We're not sure how we might mitigate those harms, because we'll only know once we try it. I think that will be revealing.
Yeah.
Okay, so at different points throughout our conversation, Tom and I have said, do we have agreement on X? Like, are these the right harms? Are these the right, that kind of thing? Are folks comfortable with us? Do we feel like we're in a place where we could go back to the larger group and say, here's our thinking about the application right now. We feel pretty settled about these aspects. We want more information and examples about these aspects. And we kind of are not really sure about this aspect. Do we think we're at that place? Or do we want to talk about this more before we bring it to the larger group?
My sense is we could report it as here's where we are now, subject to some more review, and particularly looking at Arizona, looking at England, Wales, looking at other places, but also talking to the character and fitness folks on both sides. We need more information, but here's where we are now in our thinking.
I think that sounds reasonable.
What's that?
That sounds reasonable.
Okay, then we will proceed as sounds reasonable. I want to thank everybody for taking 2 hours on a Friday afternoon to talk about how to design an application process. We did a lot of really good work today, and that's a testament to how thoughtful you all are and how seriously you're all taking this. So thank you very much. And I wish that you have a very good weekend. And we'll all be together again, on the 12th? Is that right?
The 18th.
The 18th. So we had 2 weeks. All right. Thank you, everybody. Take care. Bye-bye.
Bye.
Good one.